Hello and welcome. I'm Peter Afrasiabi, and I filmed this program a couple of years ago, Show Trials, the Immigration Court System and Potential Reform. I can confirm it's still current as I've reviewed it, so please enjoy. Hello and welcome. Today's presentation is entitled Show Trials, the Immigration Court System and Potential Reforms. For those of you with a curious mind, you may not have experienced or learned or seen or heard or know much about the immigration court system and what happens in immigration court. And so for those who are curious, this should be a fascinating program as we walk down into the immigration court system and see what happens. What's particularly interesting, you'll find, is that it is in many respects an alien court system. Many of the attributes of our state and federal courts that we're familiar with as lawyers, but even just as citizens watching television and seeing Perry Mason and LA Law and whatnot, those types of accoutrements and attributes of our legal court system are often entirely absent and missing from our immigration court system. It's a very, very different court system, and that's part of the exploration and analysis of today's program for you. And ultimately, some of what you will see in the immigration court system from some of these real-world examples we'll walk through is actually quite shocking and leads to what can be termed and deemed a system of show trials, obviously. And that's the working title of my book published several years ago called Show Trials, which is an exploration of the difference between the immigration court system and our property rights court system. The thesis being, unfortunately, in our system, property often receives more protection than human rights and human liberty in immigration court system. So let's get started, and we're going to start with the question how we treat people in court systems and how we, in immigration court systems, and how we treat property in our traditional court systems. The first place we're going to start is with the pop star Katy Perry. That's a photograph of Katy Perry. She's in her bikini, it's at the Bahamas. This is before her massive world tour that was about to be launched. And this photograph, it turned out, was quite valuable. The photograph belonged to one of my clients who was a celebrity photo agency and got this photograph and was able to license it for large sums of money to myriad media outlets. Everyone wanted to see Katy Perry in her bikini. She's going on a world tour, biggest superstar in the world. The photo had a lot of value. Turns out it had so much value, it was also infringed a lot. And so a lot of websites stole this photo, posted it on their website, monetized the photo, and damaged my client's copyright interests in the photo. So the client comes to me and says, hey, Peter, can you file a lawsuit? We have to stop the infringers and get the photo down because my traditional licensees won't pay if it's free everywhere else. So I file a federal court copyright infringement lawsuit over this photo of Katy Perry. It's filed in federal court in Los Angeles, and I get assigned to a fantastic judge, Judge Fairbank, here in the Central District of California, and the case is underway. And then something happens. I don't show up at a hearing. There's a hearing, it's calendared, I don't show up. Call comes from the court, somehow call goes to my voicemail, I don't pay attention to my voicemail even, don't answer the call. What I get is an order a couple days later saying, case is dismissed, order to show cause, and why I shouldn't be sanctioned for failing to appear and to explain myself. And so I was obviously unhappy, it's embarrassing, it's not good. I made a countering mistake, completely missed a hearing, didn't check my voicemail, so I didn't get the call from the court at the time when I could have perhaps solved it on the spot. And so I now had a case dismissed from my client, I had an order to show cause, and I had to figure out what to do. Now, was I panicked and freaked out that, oh my gosh, I've destroyed my client's rights, this photo has now been lost, we're not going to be able to get a remedy for my client, I've committed malpractice, the world's going to end? No, I wasn't. And the reason for that is pretty simple. Judgment by default is a drastic remedy. I made a mistake, and as you know, as a litigator and a lawyer, people make mistakes. The courts generally abhor technical defaults and whatnot, and you fall on the sword, you explain the mistake, what happened, and you'll get it undone and get the case reinstated. And so on the next slide you see some quotes. Why is this our rule, so to speak, our norm of American justice in the 21st century? Well, here's a quote. "Judgment by default is a drastic step appropriate only in extreme circumstances. A case should, wherever possible, be decided on the merits." The next quote is, courts, quote, "look with disfavor on those who try to take advantage of mistakes and neglect." Those quotes come from the California Supreme Court talking about state policy, and from the federal appellate courts, the Ninth Circuit, the second one, talking about the federal policy of trials being heard on their merits. Why do we have this rule in our system of justice today? Well, one reason is we want a fair result. We don't want technicalities to decide who wins, who loses. We want everyone to have their day in court. We want all the facts to be put before the trier of fact, to be considered and assessed and synthesized, so that when someone's declared a winner and someone is declared a loser, at least we all know, the participants in the case, the lawyers, the judge, the jurors, the citizenry, right? Everyone knows that the result reached was the fairest result possible. Everything was aired out and decided on its merits. And this is critical because we do this because we want a massive amount of fair process, because that's a function of the issues at stake. In my case, for example, someone's substantial copyright interests were at stake. And there should be, by our policy quoted here, a fair set of processes in place to make sure that those property rights are protected, so that if my client loses its copyright case, it should be because it deserved to lose, as opposed to because of mistakes. And this gets us to the fairest result, the most likely accurate outcome across the widest swath of cases most of the time. Now let's turn to the immigration court system and what happens to people in that court system. Here you see a photograph of a labor protest in China. And I use this case because it's reflective of a real world case I litigated in coming out of the immigration court system dealing with a rice farmer in China. And so this is the bookend to the pop star case of Katy Perry. The rice farmer in China case starts as follows. Client was a rice farmer in China, and there was some local government corruption. Land was being taken. They were being forced to farm on different land. This land he had farmed on for generations, perhaps millennia. I mean, as far back as anyone knew, that had been the family land they farmed on. Now, all of a sudden, in some modernization going on, the land was simply being taken, and they weren't able to farm anymore, and they had to go farm a different piece of land that was arid and didn't work. And so this provoked great anxiety among the local people, and it sparked some local protests in this remote region of China. And this man in particular was sort of one of the central leaders of this, demanding that the government corruption that had led to this kind of land transfer deal and stuff going on be exposed, and that they not be allowed to do this to the people. And the consequence for his sort of activism and protesting in China is that he was arrested by the police, taken down to the local police station, asked to sign a confession of his improper conduct. He refused to sign a confession. So he was tied to a chair and he was beaten. And he was left there for several days in the cell where they would regularly come in, ask for a confession. He'd refuse to sign it. He'd be beaten again. Eventually, after days of torture, as anyone would, he eventually signs the confession and is then released. He spends a significant amount of time in the hospital because of his injuries in the local hospital. And he now has to check in with the police on a regular basis. He can't work and earn money properly. He gets continually harassed by the police. And his life has suddenly narrowed and been circumscribed to the point that it's not even a functioning, viable life or livelihood anymore. And so with the help of some distant relatives, he cobbles together some money and in the middle of the night flees. Leaves that region of China, makes his way eventually, after an arduous journey, it's another long story, but eventually he lands in the United States, makes it here, says, I need asylum. He gets into immigration court in the United States. He's not detained, so he's now, in the United States, has a court hearing set, and he goes to his lawyer. And the lawyer can't appear on the day that's set for trial. The lawyer has a conflict. and this conflict came up at the last minute. Some sort of paperwork was filed with the immigration court, but they weren't sure it was going to make its way to the immigration judge before the hearing. So the lawyer sits down with the rice farmer client, and through a translator that was hired by the lawyer, tells him, look, you need to go to court at certain time in the morning. And the lawyer tells him, your case is at 9 o'clock in the morning. You have to go down to court at 9 o'clock in the morning, take this paper, explain that I can't be there, and that we've filed a request to continue the case and ask to have your case continued. Translator listens to this, translate it, says, you need to go down to the court in the morning, take this paperwork, explain what had happened, and you need to be there at 11 a.m. Now you see the dilemma that occurs. He shows up at court at 11 a.m. and there's some other cases going on. He waits and waits and waits, and his case never gets called. He doesn't hear his name called. And so then the last people are leaving the court, and he rushes up to the clerk. The immigration judge is literally still sitting on the bench, and he waves his paper and says, you know, in his broken English, explains, I'm Mr. So-and-so, here's my case, what about me? And the clerk looks up the case number and says, yes, your case was called at 9 a.m., you weren't here, you're ordered deported. And these are called in absentia orders of deportation. They are quite common. In fact, they occur to the tune of thousands of cases a week of people being deported in absentia because they miss the time of a hearing. So he goes back to the lawyer and says, this is what happened. The lawyer says, oh, yikes, we got a problem. The lawyer then files a motion asking the immigration judge, please reopen the case. There was a calendaring mistake. The translator gave him the wrong time. And so if you pause here for a second, you juxtapose how that lawyer was feeling compared to how I felt in my, pop star photograph case. This lawyer, it turns out, was a lot more nervous than I was. He files the motion with a declaration under penalty of perjury from the translator saying, I made a translation mistake. When I converted 9 a.m. to 11 a.m., it's a mistake. We were there, we're ready to go. And by the way, we had another motion. We couldn't be there that day. The government files its opposition brief. The whole thing becomes sort of 2 inches of paperwork fighting about diligence and the need to respect the legal system and to care about times and hearings, et cetera, et cetera, et cetera. Immigration judge decides, too bad. Your translator and your lawyer, your agents, they made a mistake. Even if it's true, you live and die by their mistake. That's life. You're ordered deported. Refuses to reopen the case. So the lawyer appeals it to the Board of Immigration Appeals, and this is the appellate immigration set of judges within the executive branch of government that decide decisions for immigration judges. Now they're clinging to doctrines about deference to the fact finder, deferring, and those types of appellate doctrines, and they affirm and say, yep, nothing we can do, too bad. Translation problem is your mistake. And so I then took this case on a pro bono basis coming out of the immigration courts up to the U.S. Court of Appeals for the Ninth Circuit. And what's curious about it is I took it at the exact same time I was taking this appeal for this man. I missed my hearing in my Katy Perry case, and this jarring dissonance between the two court systems became particularly clear to me because I was litigating both of them at the same time. One involving property rights, one involving literally human rights, liberty and life rights, which are obviously at least as important as property rights within our constitutional system, one would hope. And so I take this case up to the Ninth Circuit, I brief it, I litigate it, I argue it, and ultimately we lose. The Ninth Circuit, based on doctrines of deference to the immigration court system, et cetera, conclude nothing we can do. It's the executive system, that's, their rules, deference, whatnot. So this man then is ordered deported. And he never got his day in court. As he was ordered deported to China, we don't know if truly he should have lost his case or if he should have won, because the case was never heard on the merits. My copyright case, on the other hand, got adjudicated on the merits, and eventually my client prevailed and received some sum of money, and justice worked the way it should. And so what we are now getting at as we look at the next slide, of course, is what are the various attributes of our traditional federal and state court systems that are particularly important and are emblematic of the incredible system of justice that we in the United States have. The first one on the list you see is, we have neutral Article III courts. These are to protect property and criminal and civil rights of all people. Do we have a transparent vetting process for our judges in our, for example, federal courts and state courts? The answer is yes, we do. Is there a right to appeal? There is a right to appeal in our court system. So if you go to trial and lose, you can always appeal and ask a higher court to fix what you believe was an error, and you can get another set of judicial eyes to look at the problem. Do you have a right to a lawyer? Well, you don't always, obviously, but you do in certain contexts when your liberty is at issue. So, for example, criminal cases, even if it's a mundane minor misdemeanor case that's only going to result in a fine without any jail time, because it's a criminal case and it has serious repercussions, you have a right to counsel, and the state will pay for you to have a lawyer defend you. Do you have a right to legal fees if your property rights are violated? I mean, not always, obviously, but you do sometimes. Congress has obviously concluded that certain property rights are particularly important, and if violated, the losing party can have to pay the prevailing party's attorney's fees. And this is particularly common, for example, in the copyright context, where the prevailing party gets fees. We have it in other intellectual property areas if you have a showing of an exceptional case, and we protect trade secrets at the federal level and at our state levels the same way with a right to attorney's fees. One of the other attributes of our judicial system, of course, is mediation. And so one of the questions that we're going to be looking at today is whether you have a right to attend mediation to try to find a resolution that everyone can live with. And the answer is yes, you do. And then the question is where we started. Do you have the right to have the case decided on the merits at nearly all costs? And this balance of fairness and efficiency, the answer is yes in our traditional court system. Let's now start thinking about some of those attributes of our traditional court system, which we're all familiar with from being lawyers, of course, and litigators, but even transactional lawyers from law school and lawyering in the system, but even just from watching media and being familiar with TV shows about lawyers. All of those things make sense as being just as American as apple pie when it comes to our legal system. As we turn the page now to the immigration court, one of the first things that we need to think about is it a neutral court system, like our Article III courts or our state courts that get removed by and large from as much as possible from the politics of the day to ensure that the courts are neutral? It turns out in immigration court, they're not. It's not within the judicial branch of the government. It's within the executive branch of the government. The executive branch of the government controls the immigration court system, makes the rules of that court system, appoints the lawyers to prosecute the removal, in other words, deportation of people, and puts the judges on the bench of the immigration court to decide those same cases. And so if we peel back the layers to the onion a little bit to look at who are these people who become judges, we learn that in the immigration court system, there's no public vetting process. And this public vetting process, of course, is particularly important. If you stop and pivot here to what happens in our normal court system, there's massive vetting brought to bear on folks who are going to become our state and federal judges. You get letters, I get them, you get them from your state bar saying so-and-so wants to be a judge, give me your comments, your feedback, do they have good temperament, good wisdom, etc., etc. As potential judges work their way up on the federal side, they get screened by the American Bar Association, their local committees. They run through all sorts of committees, and then they get put before public hearings before the Senate for confirmation. And of course, sort of the quintessential example is like the Justice Thomas hearings that were broadcast on CNN for days as it mesmerized the nation as the nation studied and got to the bottom of Justice Thomas and his background, etc. And that process is particularly important, to have sunlight just brought to bear on these people who are going to be our judges appointed for life, deciding property, life, liberty cases. We want to know as much information as possible. There is no such process in the immigration court system. They're simply folks who apply for the job to be an immigration judge, and they fill out the application, they apply, and they get appointed by whatever metric the executive wants to use to put them on the bench. And now they're an immigration judge. Interestingly, you only need 7 years experience as a lawyer to become an immigration judge. And as it turns out, you don't even need immigration experience. Again, we can pivot to our, for example, state court system. If one of you watching out there want to be a small claims court judge in the state court system, deciding really our pettiest disputes, right? Someone spat on your property or their tree branch broke your fence, whatever, that type of stuff in small claims. You have to have, in California, 10 years legal experience to be a small claims judge. Immigration court, you only need 7 years to be deciding cases such as the case of the rice farmer I told you about. And the other aspect to the immigration court system is that if the immigration judges tend to be too liberal or perhaps too politically extreme one way or another, they can be fired because they serve at the discretion of the executive. And the famous example is from the early 2000s when President Bush was elected and then Attorney General Ashcroft was in charge. There was what's been known as the Great Purge. And there was a body of immigration judges at the Board of Immigration Appeals who were perceived as being just too liberal, too easygoing, whatever, on immigrant rights cases. And so they were fired in what was a great purge, as many were fired all at the same time. And that aspect of the ability to control the deck of judges, so to speak, is unique to executive controlled court systems that we are not used to in our normal court systems, of course. The next metric we can look to is, okay, that's how the judges get on, but let's dig a little deeper and compare the judges and figure out maybe the judges are as good as each other, maybe they're not. And there are some metrics that we can look at to try to get to the bottom of this. And so one is by comparing the immigration judges who decide those cases to our traditional district court federal judges who decide our traditional property, criminal, civil disputes. As it turns out, about 50% of all of our normal judges have had prior experience judging. Maybe they were a small claims court judge, a municipal judge, a superior court judge, an administrative law judge of some kind. The point being, before they become a district judge, almost half have had some experience in the trenches of judging human beings, making decisions about credibility, honesty, justice, fairness, morality, the law, applying it, all the stuff that judges do to develop that Solomonic wisdom we hope they have as they decide the fate of the cases before them, that incredibly difficult responsibility and massive responsibility they shoulder. So 50% have had some experience in different trenches before they reach the point of deciding, property, criminal, civil rights type disputes in our courts. On the immigration side, however, when you look at the data, less than 10% of immigration judges have ever had any kind of prior judicial experience deciding cases. And that's a 5 times multiple difference. It's a massive, massive difference. The next slide has data looking at the years of experience. And all this data comes out of my book from around 2012 called Show Trials. And this slide compares our immigration court judges to our district court judges. The immigration judges are the light bar and the district judges are the dark bar. And what we're looking at here is the percentage of judges with the noted years of experience. And it's a particularly interesting set of bar graphs here. If you look at the immigration judges, and this is data as of 2012 for the sitting body of judges at that time. If you look at the percentage of immigration judges who have less than 15 years experience just as a lawyer, it was almost 40% had only been practicing law for sub 15 years. And if you comparably look at the district court judges who were on the bench at that time, how many of them had been appointed to the bench with less than 15 years of experience, it was a low number. It was around 6 or 7%. Again, looking at a near 5x multiple difference in terms of the minimal number of years of experience. And this is reflective of the idea, of course, that undergirds this, is that years of experience of a lawyer is particularly important, just to have seen, experienced, litigated, developed that wisdom that comes through time, just being in the trenches, the experiential nature of learning that develops a skill set that can help you then be the decider of the fate of other human beings, which is why so few of our federal judges have had such little experience. Conversely, so many of the immigration judges have had so little experience. And those numbers are interesting. You look at sub 10 years, there were the percent of federal judges, I think that bar graph represents, it was literally one judge as I remember, it may have been 2, but I think it was one judge out of like 800-900 judges had less than 10 years experience. I mean, so it's obviously an anomalous appointment through the political process and the system, right? But on the immigration judge scale, on the other hand, it was almost 10% of the judges that had sub 10 years experience. And no offense to those of you who've only been practicing for sub 10 years, but sub 10 years, that's not a lot of experience to reach the point that you're deciding the fate of human beings. It's just, the law is experiential and difficult. Now, what's so interesting on this graph is it flips. As you start looking at greater years of experience before becoming a judge, you see over 60% of the federal judges had at least 20 years, if not more, experience in the trenches of lawyering before they found themselves on the bench. And conversely, now the numbers have flipped the other way. It was under 30% of immigration judges had over 20 years experience. And the numbers get even more significant when you get to more than 25 years experience. You're at 35% of the federal judiciary had at least 25 years experience lawyering, whereas it was 13% or so of the immigration judges. And so what this shows is, regardless of how one feels about whether it's right or wrong, it just simply shows, in our federal court system at least, our judges have substantially more experience before we task them with the role of deciding disputes over our fate, so to speak. And those in immigration court have just had substantially less experience before they get tasked with deciding the fate of human beings in those cases. And it is what it is, but that's the nature of part of the reason for a difference in system. Now, the next data point we can look at to sort of peel back the onion a little bit more to ask the same question, are the immigration judges as qualified as our normal judges, is, well, what's their reversal rate? Do they get reversed a lot or do they get reversed a little? And that's at least one metric. It's not dispositive, obviously, just as the years of experience isn't dispositive, but it's another metric to look at to try to get a flavor of how good a job are they doing. And so if you look at the data from 2000 to 2010, it turns out in the Ninth Circuit, immigration judges were reversed 2 times more than the district court judges. And that's a pretty staggering differential if you stop and think about it. And in some years, they were reversed 4 times more than our normal federal court judges. That's something, because this same body of appellate judges reviewing the work of the immigration judges and the work of the district court judges, this same body of people are deciding that one group is erring at rates 2 or 4 times more than another group. And so this starts painting a picture that perhaps these people aren't as qualified as our normal judges. If we start with our traditional federal courts, for example, there's always a right to appeal. And in fact, if you stop and think about one particular form of property, and that is our patents and patent rights, they are so important to us as a nation that we have created a singular appellate court system only for patents. And that is the Federal Circuit Court of Appeals in Washington, D.C. Literally sits across the courtyard right near the White House. And so this court system is to bring uniformity to and to make sure that patent disputes and patent cases across the country are adjudicated fairly and properly. And so in all patent disputes, you have a right to appeal to a specialized court. And the right to appeal, of course, is sort of just as fundamental as American as apple pie, right? If one feels aggrieved, you say, I'm going to take an appeal. To have another set of judges look at what happened and decide if the first judge was appropriate, was fair, was just in terms of the decision reached based on the facts and the law. And, another example from my practice, for example, is my copyright cases. Those go up to regional circuit courts, but I had one copyright case where my case was dismissed at the Rule 12 stage. I took an appeal to the Ninth Circuit. They reversed and reinstated my case. I went back down, we litigated through discovery, and then the district court judge granted a summary judgment to the other side. So I took that up on appeal, and I got that reversed also. And the case then got remanded and sent back to go to trial, and then I went to trial. The whole process took years, but my client's copyright interests were so protected by our appellate system that I was able to take 2 appeals in the same case, get the case reversed both times, and then eventually get the case put before a jury. It's a fantastic result. And it's the nature of our appellate system. But if we pivot, of course, to our immigration system, as you're getting the sense, we will start seeing things as being a little bit different. So, starting in 1996, there were some amendments to the immigration laws through the Illegal Immigration Reform Act of 1996 and through the Anti-Terrorism Effective Death Penalty Act of 1996, which took a bite at some of the immigration stuff too, even though it was also dealing with death penalty and habeas law. And so what happened is that the Congress passed some laws which President Clinton did not veto, and so they became law. The bills became law, which eliminated the right of judicial review of certain executive immigration court decisions, a certain subset of decisions those decisions of the immigration court were deemed final and conclusive, no appeal to the neutral Article 3 branch of government. And that particularly is in the question of hardship. And these are cases that are known today by cancellation of removal, and in the older case law they were called suspension of deportation. Essentially the same basic litmus test. The concept being for people who have been here for many, many years, who have U.S. citizen qualifying relatives, such as perhaps children born here, they have good moral character, no criminal problems or anything like that. There is a limited mechanism in the immigration laws to allow them to cancel the removal proceedings that may have been initiated against them and adjust themselves to have status in America. But to do so, they have to show they've been here a long amount of time, that they have good moral character, but they also have to show that the removal of them and their family from the United States would ultimately impose an extreme hardship on the qualifying relative. And so one example that I've litigated in the immigration court arena involves a family who've been here for over 25 years and multiple U.S. citizen children, one of whom was diabetic and had the need for insulin and had health care here. And the family had never had any problems, just your prototypical members of a community, go to church, paid a variety of taxes, and were just living in their American community. And were put into removal proceedings, and the immigration judge heard the evidence and decided that even though the medical evidence was that this medical treatment was really needed here for diabetes and it would be very, very hard to get in the country down in Central America that they were being returned to, and they feared for his safety, the court concluded, medical stuff, not a big deal, it's no hardship. And that was the decision of the immigration judge. And so the case came to me on appeal to the Ninth Circuit, and I tried to take this case up to the Ninth Circuit, but because of those laws that I just mentioned, the Ninth Circuit concluded we don't have jurisdiction to entertain that hardship decision. And so that decision's final. We don't get to pass on it. Even if we disagree with it, even if we would have come to a different conclusion, we literally don't have the right to review it, and that's the decision of Congress. And so that is just a prototypical example of cases where the decision of the immigration court is final, unreviewable, and it's the end of story. And so that immigration judge's decision, that was it. That removal was not canceled and the family had to leave. Another sort of attribute of our judicial system that we can look at as we continue down this comparison of the two court systems to really get to the bottom of whether we have show trials in immigration court is the question of a right to a lawyer. As you see on the slide, 60% of those in immigration court appear pro se. Only 40% end up with counsel. And the reason for that, of course, is primarily an economic reason. Folks in immigration court don't have deep resources to pay lawyers. It's sort of an obvious proposition when they're fleeing, foreign countries and coming here, or they're just, coming to the United States. And what we have in immigration court, as you see on the second bullet point, is that there's no right to a state-appointed lawyer to defend anyone in any kind of a deportation process. And this is true irrespective of whether the alien is detained or not. So even if one is detained in a detention facility and they have to go to immigration court, they still have no right to a state-appointed lawyer. And it's also true that it's irrespective of whether the person is perhaps a political asylum seeker facing a risk of harm or death if they're returned, versus just your run-of-the-mill person who says, you found me, I've been here for 15 years, I don't want to be deported, right? Regardless of what case it is, there's no right to a lawyer, and the state won't provide a lawyer. Now, if we pivot to for example, our criminal system where, whether it's a serious death penalty case or whether it's a minor misdemeanor case, there's always the right to a state-appointed lawyer. And the Supreme Court has found this in the Constitution and as a hallmark of due process, because before someone's life, perhaps if it's death penalty, or their liberty, if they are going to lose some amount of time and go to jail or even have a criminal conviction without jail pinned on them, before that liberty interest or life interest is implicated, there must be a lawyer appointed to make sure that we as a system can know that if that is the punishment they ultimately experience, it's one that they deserve and was found after a full and fair hearing. And the only way to ultimately have a full and fair hearing is with the appointment of counsel. And this is Gideon, and it goes back to a whole line of cases like that. So, even though someone's in immigration court facing perhaps a risk of death or torture if they're returned because the country may kill them if they're a political dissident or they were practicing a religion that's illegal in the country that they left, there's no right to counsel. Even though the same liberty and life interests are implicated, there is no right to lawyer. Another attribute, as we turn to the next slide, that we can think about is whether the prevailing party has a right to fees. And this is sort of an interesting concept to consider in our legal system. In the immigration court system, the answer is no. If you get a lawyer, you litigate, and you prove that you were unjustifiably put in deportation proceedings, you have no right to fees, and so you don't get to recoup the attorney's fees. Now, that's not true in certain areas of property and civil rights. For example, the Copyright Act provides the prevailing party with attorney's fees, and so does civil rights litigation in 1983 litigation, for example, and even trade secret litigation at the federal and state level. The protections provide attorney's fees. If we, again, peel this onion a little bit to understand why we have this in our system, it's a carrot-type stick problem. The perfect way to look at it is that the Copyright Act, in terms of protecting copyrights, they've been deemed important from a social policy perspective for a long time. It's been assessed that artists, musicians, creators, those in the creative class often don't have resources, often get taken advantage of by those with resources. And so this right to attorney's fees is granted because Congress, the body politic, ultimately has concluded that it's important to protect people's copyright interests, and we need to know that they can't really afford lawyers, so we need to incent the bar to come and protect them. And the way we do that is by the bar knowing you can come and represent these people even if they can't afford to pay you. You can do it on a contingency and get your attorney's fees back, and there's some way to monetize the relationship, and then that acts as a draw for lawyers. The same is true in 1983 litigation, and in fact 1983 litigation is a fantastic example to look at because when the civil rights statutes were first passed, there was no right to attorney's fees. And many, many years went by, and Congress looked at it and concluded that the civil rights statutes and the normative promise in the law in terms of what they should be doing to remedy the injustice, it wasn't being used properly. And part of the reason they concluded that was that there was no right to attorney's fees. And so the bar wasn't being drawn, it's like a magnet. Lawyers weren't being drawn into this area to take on representations to vindicate the policy of the law, the civil rights policy, because there was no right to fees. And so Congress, therefore, enacted the 1983, this 42 U.S.C. 1983, those statutes that allow you to seek remedies for civil rights violations. They added what's known as Section 1988, which provides the prevailing party with attorney's fees. This, in turn, caused more and more lawyers to enter that area and be willing to take on representations that may not be ones that the people could afford to pay lawyers for or didn't even perhaps have financial value to them that a lawyer could monetize on a contingency, but there was a right to fees. And so lawyers willing to take those cases would come in and take the cases. And indeed, it's breathed even more life into the civil rights statute. So this carrot stick concept of having a fee statute is particularly important in our life and liberty and our property legal arenas that we use to incent lawyers to join the fray. We have not done it in the immigration court system, though, so you don't have lawyers entering that area to represent that 60% number we spoke about. So as we continue to look at all the different dimensions to this problem, we're sort of moving around the immigration court system now, looking at all aspects of it, we get to, of course, those lawyers who are there. What about them? Turns out those lawyers are sanctioned 10 times more than non-immigration lawyers before the Ninth Circuit. And that comes again from data in my book, Show Trials. That's a massive differential when you think about the court system and the judges who are looking at the behavior of lawyers and whether they've transcended the bounds of propriety and how they represent their clients. That bar group, for whatever reason, has been sanctioned 10 times more than non-immigration lawyers, showing that they are overworked, underpaid, and under a lot of pressure for their clients, obviously. An interesting little flip side anecdote here is that in this area of law, the government lawyers cannot be sanctioned, but the private lawyers can. So this just adds to this sort of tilting level of playing field, so to speak, as cases get litigated in the immigration court system. The next slide we turn to is mediation. Mediation, of course, it's known. It's in civil litigation. For those of you who are litigators, you know it. For those of you, even if you're a transactional lawyer, you certainly know about cases going to mediation. Your clients go to mediations and find resolution. Now, mediation is not a modern invention. It's not the product of 20th century American jurisprudence and some magical creation that we came up with. It actually has really ancient lineage. It goes back to biblical times and even the ancient Sumerians. And it's been a means of problem solving that has been employed by myriad cultures from all corners of the planet for thousands of years. And the reason for this is simple. It is difficult sometimes and risky for people to go before a finder of fact where there will be a winner and a loser. And sometimes everyone is happier if you can find a resolution where everyone gets something even though no one gets everything they want, and people can then leave on friendly terms and be happy and comfortable with what they've received. And so this facilitates happier people coming out of the system ultimately. And so as you fast forward from the ancient world to the modern world, we employ mediation on a regular basis. If we stop and pause and think about our civil court system, it's required. I practice intellectual property law in the federal courts in California primarily, and in the Central District of California, there's a requirement that you notify the court early on in your case what form of alternative dispute resolution, what form of mediation, so to speak, you choose to use in the case. The parties have to discuss it, and that's a very, very common requirement in state courts and in all federal courts. And you decide if you want to go before one of the local magistrate judges, if you want to go before a private mediator, if you want to use some lawyers who do it for free on panels. There's a whole set of options, but you have to pick one because it's required, because it's seen as being important and valuable to reaching case resolution and to achieving justice and saving the system unnecessary resources ultimately in a way that gets people to happy outcomes. So, now we can pivot again to our immigration court system, and I'll give you an example of another political asylum appeal I litigated where mediation was a big question. This one involves an elderly woman from Armenia who, she and her husband, during the collapse of the Soviet Union in Armenia, they became the victims of religious persecution. The ethnic control was shifting in their region, and they effectively got marginalized by the community and threatened, and people just literally took over their home and lived in their home, and they were forced to live on their balcony and sort of function almost as quasi-slaves for some amount of time, and then were left effectively homeless. The children had managed to escape to America, secured asylum at the time, and this was in the early 90s, and had a life in America and then had kids here. And this elderly woman, though, her husband eventually died because of sort of the situation there, and she eventually was able to make her way to the United States. Now, she could have secured asylum via her daughter, who did file a status application for her to give her status in America, this I-130 application, but the daughter had problems with her husband, and the husband effectively was threatening the daughter, and the daughter had to cease supporting her mother's bid for citizenship. So the mother only had to now claim asylum. And so the asylum case was put on. They had a lawyer before the immigration court, and the asylum claim was built around the idea that, this is about now 10 years later, 10 years ago, this stuff happened in Armenia, and it's, she doesn't want to go back, it's dangerous, she could be tortured again. And the government put on evidence that, all that stuff's terrible, but, it's changed in the last 10, 12 years. It's now safe to go back, and you won't be tortured. So even if what happened and is bad, it's now safe, no harm, no foul, basically. And there'd been enough passage of time, so to speak. And so the immigration judge agreed with the government lawyers and said, nope, you don't get asylum. And then it went on appeal to the Board of Immigration Appeals. They said, yeah, you don't get asylum. And so then I took the case up to the Ninth Circuit from those lawyers, and our argument in front of the Ninth Circuit was, this is the last court to ever hear this case. She's 76 years old or so. She now has real medical issues that we had documented in the record in terms of her health and even, frankly, the danger of getting on an airplane and flying because of her medical conditions, that type of stuff. And we had to argue the case and did all the briefing, but it was obviously a difficult asylum case. It was no slam dunk case, that's for sure. And at the oral argument, I argued my case. The government lawyer got up and argued her case. And one of the Ninth Circuit judges stopped the government lawyer and said, what are you doing here? Why are you trying to get rid of this ill 76-year-old woman? Maybe she gets asylum, maybe she doesn't. It's a tough case. We all get that. But why? Like, what is it that we're wasting all these social resources on to deport this old woman whose daughter clearly could have got her citizenship, but because of the daughter's situation with the daughter's husband, she couldn't. And so this funneled into the question, what are you doing here? And the court said to the lawyer, won't you mediate the case? Why don't you guys just sit down and talk about it and find some resolution, because it doesn't make any sense to be litigating this for a winner-take-all type outcome. To which the government lawyer responded, we don't mediate these cases ever, we won't, there's nothing I can do. And so then that was the end of the government's argument. The court asked me to get up and speak for a minute in rebuttal, and I got up and said, we think mediation's a fantastic idea, we want to mediate, we want to mediate, we want to mediate, etc. And the court submitted the case, and then a week later we got an order telling us you have to go to mediation. So we have the first mediation with the Ninth Circuit's mediator, and the government's position is, we don't mediate, we won't mediate, there's nothing we can do, you can't force us to, it's not going to happen. And we then come back a month later, do it again. And this goes on for a couple months, at which point the mediator starts making some progress, and we start hearing, well, maybe there's some way to come up with some middle ground solution, as strange as it is. And the panel still had the decision hanging out there over everyone's head because it hadn't been decided. And so eventually, to cut a long story short, we were able to reach the point that after about a year of endless negotiations, we found a compromise. My client was able to stay in the United States and wouldn't be deported, but my client would never be able to adjust and become a green card holder or a citizen. And for the government, it was, this is sort of an example of how mediation works, right? For the government, they didn't get everything they wanted. She wasn't deported. But they also got something they wanted. She won't become a citizen and a green card holder and be able to, gain benefits and all of that type of stuff. By the same token, I didn't get everything I wanted for my client. She doesn't become a citizen and get all those benefits. But I also got something that really mattered immensely for my client, which is she not be at age 76 and in her elderly, waning years, put on a plane back to a foreign country where she may die and terrible things could happen. And she got to then live out the remainder of her years here near her grandchildren and her daughter. And so it's an example of how mediation forced on us and after a great amount of time really works in that court system. But the problem is the court system doesn't require it, demand it. The judges don't force it. And most of the time, even when judges ask you to attend mediation and do it in the immigration cases, they refuse, and there's never able, a resolution is never able to be found. So that's mediation and the value of it to ensuring that we have a fair system. This brings us to the next slide, which is the reality of the difference between the two systems. And so, as we see here, we now have a comparative chart. Do we have neutral courts? Well, for what we're used to from Perry Mason and LA Law and whatnot, we do. But in immigration court, clearly I think we can see we don't have neutral Article 3 courts. We don't have a transparent vetting process for our judges in the immigration court system, but we do for our property rights. On reversal rates and prior experiences, are the judges comparable? They're not. When you look at the two, there's a staggering difference between qualifications on those metrics, between who we have decide our fates and who we have decide the fates of people in immigration court. Is there a right to appeal? There's always a right to appeal for our property and criminal disputes, civil rights disputes, but there's not in immigration always. Do we have a right to a lawyer when liberty's at issue? You do in criminal cases, but you don't in immigration cases, even though there's criminal overtures in terms of the imposition of potential sentences on people if sent back to foreign countries. Do we have a right to legal fees if our rights are violated to help ensure we get a body of talented, qualified lawyers to get in there and represent people? Well, we do for many of our property areas, not all, but many of our property areas we do because we value those property rights so greatly. And we do for criminal defendant rights, obviously, because they're important, and for civil rights. But we never do that in immigration court. And so this helps also explain, of course, the dearth of lawyers and the need for lawyers representing people. We've just been through mediation where there's no absolute right to attend mediation. And this then ultimately gets back to where we began this discussion, which is, do you have a right to have your case decided on the merits at all costs? And the answer in immigration court, sadly, is no, but in our regular courts it is. And so this explains the thesis of show trials and a current walk through our contemporary immigration system. And so as we turn to the next slide, we can now start talking about some kind of big picture reforms, starting from the premise that both of these court systems that we've looked at today are adjudicating constitutional rights. And the Supreme Court has long said that meticulous care is required when adjudicating constitutional rights in immigration cases to make sure that people are free from unwarranted, improper deportations. And so this massive gap between our procedural justice rights and our two court systems is one that we can look at and figure out how we can bridge to find reform so that the two court systems can move into harmony and we can be providing the same basic process in each system so that we know that the results that that system gives are as close to accurate as possible as we can realistically get given resources. The next slide looks at another set of reforms that we can talk about, and that is reforms related to our courts and the judiciary. A potential reform is to put all the immigration courts within our neutral federal courts so that, or at least some sort of court analog to like the bankruptcy court, for example, so that we have a court system adjudicating these rights that's genuinely divorced from the political process. And this is particularly important because immigration is such a political issue that generates so much social anxiety and angst and emotion, but that's precisely why it should be in as neutral and dispassionate a court system as possible to make sure that the results aren't the product of the politics of the moment. Also, this solves transparency and vetting issues. There's in a democracy such as ours that requires the consent of the governed, we demand that our judges are vetted and are as neutral as possible so that their decisions carry the force of law and are respected no matter what, because the courts, of course, don't have tanks and guns at their disposal to enforce orders. They only have the pen. And the pen and their orders only work if the system is perceived by all other constituents as being legitimate, neutral, and fair. And so that is necessary, I believe, in the immigration court system to reduce that broken nature of show trials. This also decouples politics from hiring as much as possible. I mean, you obviously, being realistic, one can't get rid of it completely, but it does eliminate a lot of it. And then this should ultimately be seen as leading to better quality of judges, lower reversal rates, and the experiential profile of the bench increases. And this allows us ultimately then to have a system where we trade efficiency, utilitarianism type concerns for accuracy and fairness to make sure cases are decided with all the attributes of justice we demand. In our current system, they're given for our immigration court system. So continuing along on our question of reforms, the next slide gets at the mediation question and the need for reforms there. As discussed, it's an ancient and current process that's used in all court systems and systems of even people disputes. The president uses it at Camp David to solve international disputes that are immensely complicated and divisive among peoples and nations and religions. And so if it works in those cases, and it works in our property and criminal cases as we try to find resolution to disputes, the question we're asked is, should it be required for people in immigration court? There is no requirement when a case begins in the immigration court system that a mediation be attended by everyone. And so this means the cases become litigation cases where they're all or nothing cases. This requires the need to litigate everything more, which expends more social resources in terms of government lawyers having to be paid, immigration judges having to decide cases, people having to appear pro se or find a lawyer to represent them. But it uses more court system and more resources of the court all the time. Whereas mediation, if required, would enable people to sit down with a mediator and with the government lawyer and figure out if there's some subset of the immigration cases that are pending that do justify and require some middle ground resolution, not a winner-take-all battle to the end type litigation scenario. And many cases do. I mean, these are cases of human beings, such as the example I gave you, that it just makes sense to find a mediated resolution. It makes sense for everyone, and it's cheaper and more effective and saves a staggering amount of resources. So if mediation were required, we would be able to reduce in many ways the caseload of these cases, and we would have a more effective system of justice in immigration courts that mirrors more our traditional courts. The next reform to think about and discuss relates to attorneys, and that is the right to fees for prevailing parties. This gets at the carrot and stick issue, and this, of course, relates to needing to incent the bar of private lawyers to join this area of law. The data we looked at earlier showed that 60% of the people in immigration court don't have lawyers. Only 40% have lawyers. Lawyers don't get paid a lot in immigration court because their clients don't have a lot of money, so they're overworked and overburdened. But if there were a right to fees, you would incent and attract more lawyers into the bar. And this exact rationale was used for 1983 litigation. Those lawyers would join, they would take cases, they would litigate cases, and then they would be able to secure a fee from the government if and when they prevailed. And if they lost, they don't get a fee. But this also enables more cases to then be tried to their conclusion on their merits so that we know the ultimate outcome was as accurate as possible. And then we've got more lawyers in this area of law, and because they're getting paid, over time, you would expect that the decision making on the front end by the government on who to deport and who not to deport would get more accurate too, because of the need to account for this downside risk if a mistake is made and a fee award has to be paid. And so now you have a whole system in place, just like we do on the copyright side, the patent side, the 1983 side. You'd have a whole system in place designed to get to the right result as often as possible for as cheap as possible, of course, and to avoid engaging in conduct that may lead to having to pay fee awards that one doesn't want to pay. And so there's nothing like the pull on the purse strings, so to speak, to get behavior to align as closely as possible with what the law demands. And so that's an important reform to consider. The flip side to this is to consider equalizing the sanction power against all attorneys. If immigration attorneys in immigration court can be sanctioned by the judges because they may do something wrong or misbehave in terms of litigation tactics, sharing information, misleading the court, the whole panoply of things that we as lawyers in a civil court can be sanctioned for also, as we should if we make those types of mistakes, then the same should be held, though, for the government lawyers in immigration court. They should not be receiving a free pass. That free pass and freedom from being sanctioned provides an incentive to play the games and engage in the misconduct that shields and doesn't enable a search for the truth and instead leads to obfuscation and games and anything but cases being decided fully and fairly on their merits. The idea that there wouldn't be equal sanction powers against all attorneys in a court system is unique. In our federal and state courts, a U.S. attorney in a criminal case can be sanctioned for misconduct as much as a defense attorney in the same criminal case because all lawyers appear equal before the court. And so the same sort of equalization should be achieved in immigration court to level the playing field and have a fuller, fairer system. A system, again, that's more akin to our traditional court systems that we are all familiar with. As we turn to our next slide, we are continuing on the question of reforms in the court system, and we're now looking at the right to appeal. And the right to appeal is a basic right. We discussed how it exists in the federal circuit for patents. It's such a basic right that there's a fantastic early U.S. Supreme Court case known as the Sloop Betsy case, and it involved a whole battle between a ship that had been seized on the high seas by alleged pirates, and it was a big fight over the ownership of this ship. And this was a very early Supreme Court case after the United States Constitution was passed and the government was formed and we now had our nation. And the Republic existed. And one of the very first cases that went to the Supreme Court was the Sloop Betsy. And it was a battle over who owned this ship. And it started in the federal district court, and the decision was made one way. And the party then was able to appeal. And one of the questions was a jurisdictional question that went up to the Supreme Court. And the Supreme Court said, there's absolutely a right to appeal this decision to us. And the Supreme Court considered this property rights dispute over who should own this ship. And the Supreme Court ultimately reversed the decision of the trial court and shifted ownership to the American owners who believed they owned this ship that they had received on the high seas. and it resolved the case. And this is sort of a quintessential, just prototypical type case. It just happens to be a very early one that enshrined the right to appeal to guarantee that accuracy is found in our disputes in our court system. There it was a property dispute, but it doesn't, whatever kind of dispute it may be, civil rights, criminal, property, we have this right to appeal to make sure that we get an accurate result. This is something that has been stripped away, as we discussed and saw earlier, by some amendments to laws in the mid-1990s, and this is something that as a reform could be critical to make sure that if we are going to have accurate decision-making coming out of executive courts, we need to consider making sure that every one of those decisions, no matter what, can be reviewed by our neutral courts so that we know every decision that is ultimately rendered is as accurate as possible. This now brings us to our conclusion. The fundamental conclusion is that our property rights system in our courts is fantastic. It works, and it works really, really well. When you go through that checklist, if you go back to one of the earlier slides, we look at a whole set of metrics that we can judge our American property rights system and our criminal rights system by, and it's genuinely marvelous. It's amazing. We have neutral, independent courts. We have a transparent process to vet and find our judges. We have a process to make sure that those who become our judges are as experienced with as much wisdom as possible, who have less weird baggage or problems or whatever. All of that gets filtered out by this vetting process. So we get people who are as genuinely good as we can possibly find to be our judges. And we do a very good job as a system at that. We have a right to appeal. We have a right to a lawyer when liberty's at issue. We have a right to legal fees in certain property cases. We have a right to mediation across a whole swath of cases. And then ultimately, we have this enshrined right to have all cases decided on their merits at nearly any cost, because we value ultimately fairness and the right result over efficiency. And so this is really a testament to how wonderful our property rights system is. And by and large, these are procedural rights more than they are substantive rights. They're really a set of procedures and processes that we employ to ensure that we achieve fairness and justice in every single case, and to make sure that every single case, whether you win or lose, you at least know you had your day in court. And that is critical no matter what, to make sure we have a good outcome on comparable fact patterns. All of those attributes of justice, we can import those into our immigration system, and we can suddenly avoid this set of show trials, many of which I shared with you as we went through this odyssey today on this continuing education. You heard a whole set of cases that sound shocking, yet they're incredibly common, it turns out, in terms of what happens. And so that's how we get rid of show trials, and we ensure that we harmonize our court systems. And then ultimately, I will leave you with how it ended for Katy Perry and how it ended for my Chinese rice farmer. The Katy Perry photos were ultimately able to be put back into litigation, and my client made a substantial sum of money, and everyone left happy. Unfortunately for my rice farmer, he was ordered deported by the Ninth Circuit. They didn't reverse the deportation orders of the immigration court. He never had his day in court or a hearing on the merits of his asylum case. The Supreme Court refused to take the case, and so he was ordered deported and had to disappear into the oblivion of history with the rest of many people who were ordered deported and their cases never get adjudicated on the merits. And so that's why this program, I hope, brings some education and exposure and experience to this very, very different court system with a fascinating look at reforms for the immigration court system. Thank you for listening. If you ever have any questions, email me at any time, pafrasiabi@onellp.com. pafrasiabi@onellp.com. Thank you.